Hello and welcome. This is Dennis Favero. I'm your instructor for this upcoming semester for the course Legal Environment of Business. As I mentioned the other day during our class session, I'll be submitting these online PowerPoint presentations for you to use. They're not to be a substitute for your assigned readings. In fact, these PowerPoint presentations that I'm going to narrate are really from your textbook readings and will give you additional background information in a very synopsized way. I hope you listen to these each week. They won't exceed 30 minutes in length, and we'll take each chapter and divide it into various sections for our discussion and study. Our first chapter is entitled The Law as a Foundation for Business. And let's talk about the term law. The term law refers to the philosophy, the principles, the standards and rules which courts apply in deciding cases brought before them. In your textbook, your authors note that the social forces that hold together societies range from custom and religion to law and economic ties. In the modern nation, however, the most significant of these social functions is law, because law can glue together diverse peoples of different backgrounds into very large organized groups. They go on to say, and this is right from your textbook, that law is known by everyone as being intended to tell members of society what they can and they cannot do. Law is made up of rules, and the rules are established by or laid down by the state and backed up by enforcement. According to your authors, the law is designed to maintain order in society and to have an adequate enforcement mechanism, such as through the courts and the police, in order to enforce or be a necessary part of the legal system. The law should be uniformly applied, not selectively, and would be enforced by the state. Under the rule of law, laws are made generally and equally applicable. They apply to all or most members of society, and they apply to various groups in the same way. They should be uniform in their application. So when we start our study, as the first chapter indicates, law is the foundation for business, we really should be looking at three concepts generally: the law, the rule of law, and property. Let's talk about property. Property in this sense is not to be confused with a substantive area or body of law, such as the substantive body of tort law, or the substantive body of contract law, or the substantive body of property law. Those are substantive areas of law or bodies of law that we will study in this course. But the term property in this context is much more generally applied. It's a general context term that is viewed within the meaning of ownership. Ownership. It means the right to turn to public authorities upon which the law delegates administration and enforcement to protect and advance ownership interest. Let's also talk about the term jurisprudence. Jurisprudence. Jurisprudence is the so-called philosophy of law. And there are various schools of thought or philosophy of law, and we'll talk about these various schools. But law is comprised of many aspects and from many sources. And within your readings that have been assigned in this first chapter, you've been introduced to some of those sources. There are really 4 traditional sources of law. And we'll go through this in some context here. The source of natural law, or the school of natural law. As your textbook indicates, it goes back to Aristotle and other ancient philosophers, where natural law theory asserts that the law contains certain universal moral principles. Principles that can be discerned through one's ability to reason, that everyone has a capacity to reason and understand through nature what is inherently right or what is inherently wrong. These principles really influenced many of our leading authors or founding fathers, as I should say, of our Constitution. John Locke was a British philosopher whose writing influenced the framers of the Constitution and thought that the term property was part of the natural law. It might be surprising to think that the framers of our Constitution, or the so-called founding fathers of our Constitution, applied natural law theory in forming the primary source of law, as it later became, being the Constitution for our law and our government. It's a very interesting area of law, or school of law, natural law that is, because it views nature as the ultimate source of reason, and reason can be applied through discernment to understand what is inherently good or what is inherently bad with a given scenario. So some natural proponents of natural law theory, or I should say some proponents of natural law theory, would be Thomas Jefferson. More modern day proponents of natural law theory could even be Martin Luther King Jr. or Mahatma Gandhi, just for examples. Let's turn to the school of thought called positive law. Now, positive law doesn't view law or jurisprudence as based from natural law principles, but instead believes that the law is simply the commands of the state backed up by force and punishments. In other words, the state posits the law upon society, and then through the state, that law is enforced. In your textbook, there's a note that the 18th century philosopher Jeremy Bentham ridiculed the idea of natural law as nonsense upon stilts. So, different schools of thought had different theories for the application and source of law. Let's turn briefly to the school of thought or school of jurisprudence called historical law. Now, that school of jurisprudence views law from a historical perspective. In other words, the law shouldn't be necessarily viewed as sourced originally from nature or by the state. Instead, law would be viewed as a compilation over time of recognized rules of law that society has chosen to enforce, and that they may be a composite of a lot of different aspects of law, arriving at an acceptable norm from a perspective going back and looking at law from a progressive standpoint. Historical school of law. There's another source of law called sociological jurisprudence. And sociological jurisprudence supports the idea, as your authors note, that law can and should change to meet the new developments in society. From this point of view, as your authors note, the Second Amendment, even to the U.S. Constitution, which asserts the right to bear arms or weapons, should not be interpreted today to allow citizens to own and carry lightweight, fully automatic rifles that can fire hundreds of rounds a minute. Your authors indicate in this textbook that when the Second Amendment was written, a highly trained person carrying a 25-pound rifle could only fire 2 rounds a minute. So a sociological jurisprudential perspective would suggest that the law could be used as perhaps a tool in which to shape what the rule of law would be for a present sociological need as perspective for enforcement. Now, counter that with the other realm or the other aspect from the sociological jurisprudential school, and that would be the concept of legal realism. Now, legal realism tries to go beyond just the words of law, as your authors note, and looks at the source. And the source could be, for example, a judge interpreting what the law is. A source, or the law being not so much a tool, but a product from which enforcement can be based. So several of these schools of law jurisprudence overlap, and there are certainly areas for discussion and for further study, but your authors wanted you to examine this area as a source to provide a deeper understanding as to how the law arrived to the point where we have today. And your authors wanted you to have perspective in understanding these laws as we go forward in our study. Let's talk about classification of laws. Classification of laws. There's common law and there's civil law. Common law refers to a legal system that really places emphasis on the role of judges in determining and interpreting what the law is. Now, I presented a handout for your study, and hopefully you've had a chance to read it, but common law uses the term case law in its application. And there's some history with this. We'll talk about common law in just a minute, but let's also talk about the concept of civil law. And again, these are classifications that are found within your course book. Civil law relies more on legislation than judicial decisions to determine what the law is. With common law, courts focus heavily on the concept of precedent. In civil law, courts focus on what is a source of legislation or code. So you should note the distinction between common and civil law, and that's found in your textbook. I want to give you a little more background regarding our common law doctrine. The origins of our Anglo-American legal system really date back to 1066 when the Normans conquered England. William the Conqueror and his successors began the process of unifying the law, or unifying the country, under so-called rules. One of the means that they used to do this was to establish the king's courts. Before the Norman conquest, disputes had been settled according to local customs and traditions in the various regions of the country. Now, the king's courts sought to establish a uniform set of customs for the country as a whole, and what eventually evolved from these courts was the beginning of common law that comprised a body of general rules that applied throughout the entire English realm. Now, eventually, the common law tradition became part of the heritage of many nations that were once British colonies, including the United States. So there's information on the development of common law in your textbook that I'd like you to really focus on as well. And that's, again, further referenced in this handout material that I made available. Let's talk about some other terms. And as I mentioned the other day when describing the course, you need to understand what some of these terms are. And to understand what the terms are, you need to read, and if there's confusion, look at the textbook and look at the end of the textbook that will guide you to where some of the terms can be sourced and better defined, not only by their meaning and description, but also by their application. So when we talk about substantive law and procedural law, these are different terms. Substantive law refers to bodies of law, such as the body of property law, the body of contract law, the body of tort law. Procedural law, on the other hand, are the rules by which the substantive laws are applied. Courts depend upon procedures and a process by which the substantive laws can be applied to arrive at some decision or adjudication. There's a distinct difference between the terms substantive law and procedural law. Procedural law deals with rules and the process and the means. Substantive law will be viewed from a source of common law that is ultimately developing into a recognized body of law, such that we've just described. Now, some other terms would be public law and private law. In your textbook, public law includes those matters that involve the regulation of society as opposed to the regulation of claims or defense of claims against individuals or individuals claiming rights that have been violated by other individuals. Public law as opposed to private law, it seeks justice to achieve the ends of society, as your authors indicate. And there are examples of public law. There's more of a public application to the rule of law. Constitutional law is an example of public law. Administrative law is an example of public law. Criminal law, which specifies various offenses against so-called the state, even though individuals are involved, the state is tasked with the enforcement of the rules so that the order of the state can be carried out. So private law, on the other hand, would be more individualized application of the law. Private law covers the legal problems and issues that concern private resource relationships with other people or other private institutions. And examples of private law would include tort law or employment law or property law in the most narrow sense, not the context that we described earlier as property law, but property law dealing with rights of real estate owners and enforcement of their interest. Contract law, for example, would be another private law source. And then there are sources of law. Sources of law. And again, I'd like you to refer to your handout and also the text. But in your handout, there are four primary sources of law. constitutions, statutes, administrative regulations, and judicial regulations are typical examples of primary sources of law. In the United States, laws are formed from several levels of government. All of the states and the national government, for instance, have constitutions and enact statutes, while every level of government, even down to municipalities, issue administrative regulations. So federal law is a source of law, state law is a source of law, judicial decisions or case law is a source of law. In your textbook, you're going to see a term called the Uniform Commercial Code, or the acronym would be the UCC. Now, we're not going to study the UCC in any detail, but we're going to mention it again during our study or examination of private contract law. But the UCC, for example, would be an example of state law that is a source. Let's talk about the term stare decisis. The rule that a court decision becomes a precedent to be followed in similar cases is the doctrine of stare decisis. Stare decisis is a concept that you're going to need to be very familiar with in this course. And it's a concept and doctrine that is really at the forefront of our common law system. The rule that a court decision becomes precedent to be followed in similar cases is really what the doctrine of stare decisis is all about. Court decisions do not necessarily deal with new problems or make new rules. In many cases, courts apply rules as they have for many, many years, even centuries. These time-honored rules form the so-called common law for which the doctrine of stare decisis is applied. A precedent is a decision that furnishes an example or authority for deciding subsequent or later cases involving identical or similar legal principles or facts. You probably want to know what stare decisis literally means. Well, in Latin, it means to stand on cases, stand on decided cases. Under this doctrine, the judges are obligated to follow precedents established within their jurisdiction. The term jurisdiction, again, another term that needs to be understood, defined in your studies for your own understanding, obviously, is to refer to a geographic area in which a court or courts have the power or the recognized authority to apply the law and decide cases. There are advantages to stare decisis, and I suppose that there are advantages. There's also disadvantages. And the advantages are listed in your textbook, as well as are the disadvantages. You need to be familiar with how stare decisis is applied to our common law heritage. And one important advantage of stare decisis was that people became secure in their right of so-called property. They then became willing to invest resources in fixed locations for factories, for example, or other immovable valuables because they were certain that the state would not seize these resources for their own use. Now, I'm actually reading from a section in your textbook. Case law helps specify in great detail the boundaries of our property-based legal system and its prospects for what is proper to people from the inference of others. But stare decisis can promote a sense of stability and reliability, and it allows for a predictive nature of one's business decisions that are being made. So if you've got a very stable application of law, then stare decisis may help promote the development of property in its very general sense, the development and protection of property in its most general sense. Now there are disadvantages, and the disadvantages would be the volume of cases. If our judicial system depends upon cases, and cases are going to be decided upon by judges in our court systems, stare decisis may lend itself to conflicting precedents. Sometimes in searching prior cases, attorneys may find cases in judicial decisions that may even conflict with each other. And conflicting precedents do not create the confidence in law that one might expect stare decisis principles to promote. And there's also the concept here of whether there is a decision that ought to go against stare decisis application, and when that new area of law or new rule of law should be imposed and why. So please read in your textbook the advantages section and the disadvantages section of the application of stare decisis. I think you'll find it interesting and very thought-provoking. And that should be the end of this first chapter. Again, it's only by way of overview and discussion that I wanted to have you think about these concepts, and for our purposes, a discussion regarding same in a very limited sense. Thank you.